Good morning, everyone. As chair of the Post Commission, I call to order our 32nd public meeting. We welcome members of the public who are in attendance. I will now begin the meeting by simply asking each of the commissioners whether they are in attendance to clarify that we have a quorum. Commissioner Bluestone?
Here, good morning.
Commissioner Calderon?
Present. Good morning, everyone.
Commissioner Sherry?
Here, good morning.
Commissioner Ellison?
Good morning and Happy New Year. Present.
Commissioner Kajirosian?
I'm here. Good morning.
Commissioner Luma?
I'm present. Good morning.
Commissioner West?
Good morning, everyone. Present.
And Commissioner Wynn?
Good morning, present.
All right, we have a quorum. Every one of the commissioners is in attendance. At this point, we turn to the next item on our agenda, which is the executive director report. Our executive director, Enrique, will now speak.
Thank you, Madam Chair, and good morning, commissioners. Just by way of clarification, we did have in the agenda potentially the approval of the minutes of the last commission meeting, but we don't have them ready for you. They were not included in the packet. We'll come back with those minutes at the next commission meeting. I will also mention for the members of the public in attendance, as is our custom, that we will not be taking questions or comments directly, but members of the public can use the Q&A function, and we'll reply or respond to those questions at a later time, right after the meeting. I'm going to share my screen to just go over the executive director report, as is my tradition, and will give me a minute. I take everybody can see this. What I want to focus today, by way of update, is one of our most recent dissemination of information and process. And commissioners will remember from last time around, you approved us to begin sharing information on those suspensions. On January 3rd of this year, we published a list of 15 suspensions. There are 3 more that are about to that have been notified, and 2 more in progress. This is going to be likely the trend. This list will be updated from time to time, as some individuals might fall into that list or fall off from that list, and I'll get into those details in a few minutes. So we are contemplating the need to publish that list on a monthly or update that list on a monthly or on a bi-weekly basis. Of course, we will always have that list with the data as of the date when that is valid. As of now, all individuals have been suspended for the reasons stated in the list and in your screens, section 9A1 of chapter 6E. And that is because they have either been arrested, charged, or indicted for a felony. We have not provided additional details at this time. As commissioners know, and our regulations provide for, the officer can request a hearing when they are notified. Our practice is to notify the officer, the agency, and the head of the bargaining unit. And the regulations provide that they can request a hearing within 5 days, and we conduct it within 10 days. What has happened, however, some officers in this list have waived the right to that prompt hearing, but have asked for a hearing as soon as the matter is resolved sometime in the future. We, of course, don't know when that date will be, and neither do the officers, although as the date approaches, we may know. So we have to plan for the process of conducting those hearings, and I'll get into those details as well in a few minutes. I should note that not everyone has in that list has requested that that hearing, but that doesn't mean that they will not in the near future. Just going on with still talking a little bit about suspensions. The way our current regulations are set up is that those suspensions are presumed to be in effect until the commission lifts the suspension. This would not apply to the administrative suspensions that now myself, the executive director, has the discretion to impose. And we'll be talking about lifting administrative suspensions later in the meeting. But we need to, this brings up a question of process and policy when it comes to lifting those suspensions. For example, if a felony charge is resolved in the favor of the officer, could it be that that hearing is still conducted by the single commissioner as our regulations provide for? Could that single commissioner take into account events since the initial suspension, notably that the charge has been resolved, for example, in their favor? Or can the commission issue a set of specific guidelines for lifting those suspensions? The alternative to these questions would be also to just simply bring the matter before the full commission, as is presumed from the statute. But because these are important policy questions, the legal team is going to work on addressing these topics, and will bring a recommendation for the next commission meeting. Just a little bit on administrative suspensions. Commissioners will remember that I have now been delegated the authority to impose administrative suspensions as the statute provides. Those are for failure to complete in-service training or failure to report information to post in accordance with Section 8. I have not exercised that discretion yet. There are a number of people that have not completed their in-service training for the fiscal year of 2022 that ended in June. And we've been advising agencies that this requirement has to be completed soon, or they may face an administrative suspension. I will also come back next meeting with updates on this. If we find ourselves in the need to issue these administrative suspensions, I'll report to you on the next commission meeting, and we'll also make that list available publicly. Of course, our approach is to first inform individuals and the agencies that this will happen before it happens, so that they can take steps to remedy the situation and comply with those requirements. Just a couple more minutes on the suspensions. As commissioners might imagine, that this list is of great public interest. They're currently on our website. There are two lists: the list of certified individuals and the list of suspended individuals. Let me pause there because I see Commissioner Ellison raised his hand.
Yes, Enrique, I apologize for interrupting. Just a quick question on the individuals that delayed their potential hearing, because these things are quite lengthy. Is there a deadline for that, or is it just indefinite as to when their situation may be resolved to come back to the commission for the hearing?
I don't believe there's a deadline. The individual will remain suspended so long as the matter is not resolved. It is in the interest of the individual, I suppose, to let us know as soon as the matter is resolved in some way, or is progressing in some way, because we can assume that they would rather not be in that list or in that status or in that list of suspended. But I don't think there's a deadline. Randy, do you know if there's anything in our regulations that might point to that?
No, there is not.
I think so. So basically, it's incumbent upon the officer, if they're in that situation, once it's resolved, to then reach back out to the commission to have that hearing. I just wanted the clarity for the
That's correct, Commissioner. We can assume that, if they're in the list of suspended individuals, they of course cannot conduct police duties and functions. They may be administratively suspended by the agency, or in some other capacity. They may be on leave. That is up to the agencies. But it is in their interest, of course, to try to get out of that status.
Thank you.
So as I was mentioning, there's the list of certified and suspended individuals. When we published that list, and since we published the first list of certified individuals, we have seen a very, very significant increase in the traffic to our website. That's especially true for January 4, when the day after we published that list. Importantly, these generated a couple of minor but important corrections. I'll give you a quick example. There was one chief who noticed that one person should be in that list and gave us a call right away that the suspended individuals, that he wasn't. And also on the certified list, we had a clerical error, and there was a small agency that was not appearing on that list. They were certainly individuals that were certified, but they were not appearing in that list. My point here is that even the publishing also ensures the highest level of accuracy, because the agencies and the individual police officers are also looking at that list and making sure that they are in the right list. I can say that upcoming, we are working very hard now as we speak on publishing the next list, and that would be the list of individuals that are not certified, because we would have deemed their matter final, and Randy is going to get into those details in the regulation conversation coming up. That would mean that the only category of individuals that will not be published in the near future would be those that are conditionally certified. And again, we'll take steps to come back to you as to the process for doing that or dealing with that last group. Okay, let me stop there. Ask commissioners if there's any questions. I will note that there will be more update in the finance and administrative aspects of the agency later on in the agenda.
Are there any questions? I don't think I see any. Thank you very much, Enrique, for your report. Then moving on to item number 3 on our agenda, the regulations update. And I turn to our general counsel, Randall Ravitz.
Thank you. I will share my screen now. Okay, hopefully people can see the revised draft of the regulations. Is that right? People can see that?
Yes.
Okay. So this is a revised draft of the regulations regarding databases and dissemination of information, which the commission had approved at a prior meeting and then were released to the public through the commission's website. And there was a period for public comment, and there was a public hearing. And we received a great deal of comments, both orally and in writing. And this revised version aims to incorporate as many of the comments that were consistent with the goals and that and the statutes and regulations that have a bearing on this area as possible, and to reconcile anything that any potential problems that commenters had pointed out. Now, the public packet included a red line version showing changes that had been made, except some as to formatting and numbering. But there were further changes made even since then, because people have continued to offer ideas for how these regulations can be improved. And those changes made most recently are in red text. Particularly significant areas, in my view, are in yellow highlighting. And then there are a few parts that the commission might consider cutting, and those are in blue highlighting. There are attachments and endnotes accompanying this document, but those would not be included in the regulations that are filed. So just to begin with one area in which there have been changes made since the version that was included in the public packet, prior references to agencies and officers have been made clearer in several places, so that there's no doubt about whether we're talking about a law enforcement agency or another type of agency. Moving down, this section regarding what a conclusion means, and therefore the point when the commission will view a matter as having ended, whether it's at the end of its own proceedings or whether the matter should be deemed to continue through any other proceedings, such as a challenge in court. This provision was the subject of a lot of discussion and differing views. And so in this version, it has been replaced with certain provisions below that were designed to accommodate some of the comments that have been offered. And so I'll discuss those in a minute. At one point, there were concerns raised about the use of the word ongoing here, since there was a provision later in the regulations that elaborated on the concept of what an ongoing matter is in different contexts, but that has been changed. So this should no longer be problematic. This section 805 was added, not since the version in the public packet, but since the prior version that was put out for public comment. And just by way of explanation, Chapter 6E includes two subsections that expressly provide for public-facing databases and two sections that refer to databases without stating they must be public-facing. So this set of regulations had already addressed the two subsections regarding public-facing databases. This new section 805 addresses the two statutory subsections that refer to databases without stating that they must be public-facing. And it provides for those databases to be established on a date set by the commissioners. Now, these two division databases, as they're called here, are treated separately from the public database within these regulations on the idea that Chapter 6E does not require these two types to be made public. But if the commission reads the statute differently, or the commissioners nevertheless believe that all information listed in this section 805 should be included in the public database, even if it's not required, it may adopt an alternative version of section 805. And if anyone would like me to elaborate on why I say that Chapter 6E does not appear to require these databases to be made public, or if anyone would like me to show what an alternative version would look like that incorporates all of this, I can do that. If not, I will move on to the next section. Okay. Section 806 deals with the public-facing database, and subsections 1 to 3 of that section concern the development of the database and what it must include. And they now, as opposed to the last version, provide for it to be established on a date set by the commissioners to make sure that the technology is in place. They do not limit it, the database, to information on active officers. They elaborate on what the summary of an officer's disciplinary record is to include, and I'll discuss that more in a moment. They already provided for the inclusion of decisions reversing actions that were adverse to an officer, but they now also provide for the inclusion of decisions reversing actions that were not adverse to an officer. And they otherwise clarify the language in various places. Here in subsection 3, this phrase, to the extent that the information is possessed by the commission, was just moved up from one spot to another so that it then applies to everything within subsection 3. Subsection 10 here, which concerns the inclusion of summaries of disciplinary records that I mentioned a moment ago, was expanded to provide for the inclusion of information as to whether complaints were submitted anonymously and whether they were submitted under the pains and penalties of perjury. So that would not require the inclusion of the complainant's name, but if a complaint was submitted anonymously, that would be indicated in the database. This subsection, which provides for public users to obtain aggregated data, was already in the existing version, but it's now been modified so that it would specify that information should be capable of aggregation by officer, by rank, by department, or statewide, and that public users would be able to obtain statistics on complaints decided adversely and those decided not adversely to an officer. And that was a way of balancing some competing views about whether complaints that were not decided adversely to an officer should be included in the database. And previously the commission had decided not to include those, at least within the summary of disciplinary records. And there was some more discussion about that and some comments from the public. So one way to reconcile all of that is to maintain something similar to that original provision, which I'll be discussing in a minute, but to allow for the reporting of statistics regarding those types of matters, even if the details of those matters are not included. This subsection 806.4 concerns exclusions from the public database. And so it now tracks the language of cited statutes and regulations more precisely. It otherwise clarifies certain language. It excludes certain personal information regarding privately employed officers in addition to publicly employed officers. So for example, officers who are employed at a private university but are subject to the commission's jurisdiction. It now excludes only those character and fitness assessments that are submitted to the commission as part of the certification process, basically at our request. So this is the subject of discussion at a prior commission meeting, and this is a way of reconciling that. It would not necessarily exclude the commission's own determinations of whether the character and fitness criterion for certification has been met. It now excludes data that is made non-disclosable under an agreement with a governmental entity at any level, not just the state level, which hopefully might help us to obtain more information from other governments. It excludes certain witness protection information that's made non-public by a regulation that has been cited by the Supreme Judicial Court. It replaces the provision that had excluded unsustained or unfounded complaints from disciplinary records, which I mentioned a moment ago, with language that I'll discuss in a minute. It's contained below. And it continues to provide that certain information will be excluded only to the extent required by the cited statute or regulation and no further, by using restrictive clauses such as that is confidential under, with a citation to a statute or regulation. And I think that that's an important point because some of the commenters expressed concerns that we would be excluding things that go beyond what a particular statute or regulation requires us to exclude. And that's not what it provides for. It stays true to the cited statutes and regulations. I'm sorry, I saw that there was a hand. I didn't see. who
Yeah,
raised it.
Randy, it's Larry Calderon. I apologize. I'm sorry to interrupt while you're running through it, but what page are you on? I'm lost. This doesn't appear to be the document that we received, or maybe I didn't print the right document.
No, this is a document that's it is the same as what was included in the public packet, except for these things in redlining that have just been added within the past couple of days, based on some additional comments. And it may be the case that the commissioners would like more time to digest these additional things.
Okay.
Yes.
Yeah,
And-
yeah, most definitely. I was having a hard time following you, and I just didn't. Okay, as long as we're going to have more time to digest it, that's fine. I can catch up afterwards. Thanks. Appreciate it.
Thank you. And by the way, any of those last minute changes, I'll be highlighting here, except for the mere correction of typos. But anything beyond that, I will be highlighting now. Also, by the way, the pagination might be different than what was in the public packet, because this version includes these endnotes as well, which are just things that I use to answer questions if necessary.
So that screen that's up right now, do you have a page so I can find where we are?
Maybe by section, Randy.
Yeah,
I know it's a little bit.
What section are we under?
Okay, so we are now under section 806 4A.
806. 806-4A. Okay, all right.
Okay.
Okay, yep. Thank you.
Okay, so and we're now at the very end of that subsection, and there's a provision here which would deal with the exclusion of certain matters that were not resolved against an officer. And as you can see, even here, there's two different versions, and they're both struck because this has undergone a lot of revision in even just the past week. So that you may have seen one, you may have seen the other, but in this version, they've both been replaced by something that I'll discuss now, which is this new subsection I. And it generally excludes information concerning a complaint that was not resolved adversely to the officer unless the commission finds that resolution to have been unwarranted. And so that reflects an effort to reconcile what the commission had decided previously, which was to exclude unsustained and unfounded complaints from the summary of disciplinary records, with some of the comments that we received to the effect that the terms unsustained and unfounded might be interpreted differently by different departments, and that different departments might have a different degree of thoroughness and different practices when it comes to investigations, so that the commission should retain the ability to make its own determinations when necessary. So this reflects an effort to reconcile all of that. Subsection J now excludes information concerning a disciplinary matter where the matter is pending before the commission, so the commission has not rendered its own final decision, or the commissioners have voted to exclude such information. And this is something that replaces that definition of conclusion that had appeared at the beginning, that was the subject of some discussion. There were some who would favor cutting the matter, viewing a matter as being no longer pending at the point when the commission makes its own decisions. But then there's also another view, which is that a matter should be viewed pending as pending and not complete during any length of time that the decision is being challenged before another body, such as a court. And so here too, this is an effort to reconcile that by saying the general rule is that it would be considered final at the end of the commission's own proceedings, but that the commission would have the ability to treat it as non-final beyond that, either by adopting a broad policy or by handling things on a case-by-case basis. Yes, Commissioner.
Thanks again, Randy. So I guess my question with your description there of how we're trying to get to, I guess, a conclusion without actually defining conclusion. I seem lost in that. So is this saying that the commission at any point in time can do whatever they want on a case?
I'm sorry.
Is that what this says?
It does leave the commission with the latitude to view a matter as being ongoing and essentially not ready for inclusion in the database, even after the commission has made its own decision on the matter based on the circumstances. So for example, it could be the case that the commission has issued a disciplinary decision regarding an officer, and the officer brings a challenge under 30A, and that challenge appears to be frivolous, in which case the commission might just rest on this general rule that this disciplinary matter should now be included in the database. However, perhaps the challenge will be such that it survives a motion to dismiss. There are indications from the court that the court is leaning towards reversing the commission's decision. And maybe in those circumstances, the commissioners might decide to hold off on putting that matter in the database. So we would have the latitude to do that.
So that's what I'm getting at. That's why I seem confused. It appears to me, again, unless I misunderstand, but it appears to me that the commission can decide to include a finding in the database on a complaint against an officer that might otherwise be in the process of appeal or some adjudication process, whether it's a court, arbitration, civil service. Do I understand that correctly? That we're saying that the commission will decide to put information in a public database that hasn't reached a conclusion in the court?
It could, if it's a commission disciplinary matter, so not just any disciplinary matter, and where the commission has rendered its own final decision, then as this is written, it could include that fact in the database. But the commissioners, you and your colleagues might decide that that's not how you want to go. And I don't mean just in the future. I mean right now, that might not be your preference. So I put that out there for discussion.
Okay. I mean, I'm obviously confused, and I'm sure anybody in the gallery that I would represent is thinking the same thing. That seems ambiguous to me. Obviously, the commission has the authority to make the determinations and the decisions and outcomes under the statute. I understand that fully. However, it seems like it's ambiguous to me that we don't define what a conclusion is. And it doesn't appear that we have a definitive definition on when the commission will include a complaint in the database. If you're telling me that it's a complaint after the commission already voted, I understand that. But if it's an open complaint that is under investigation and under appeal through the court system, why would we include something that hasn't reached a conclusion legally in a database? And that's what seems to be getting me, that I don't understand.
And let's, I see at least Commissioner Kazarosian's hand up, as well as our executive directors. Commissioner Kazarosian, please.
Thank you.
So I certainly understand what Commissioner Calderon is saying, and I think there's there's a concern also that we are transparent in what the commission is doing. So I understand that there's got to be some kind of way of being transparent about conclusions that the commission makes. So if the commission has a decision that's a final decision, and then that perhaps is going to be appealed, is there a possibility that, and I think it's important that the public know what the decision of the commission is, but I think it may also be important that the public know that that decision is under appeal. Is there a possibility, if we decide conclusion is what the commission does, because these are commission regulations, this doesn't have anything to do with the court or anything else. So is there a possibility to consider language that would be more definitive as to what conclusion means, or conclusory decision of the commission, but that we also, at the same time, if we're going to make that information public, make it very clear that that decision is under appeal. So it sort of covers both possibilities maybe, and still gives us the certainty of, or the understanding of what conclusion means for our purposes.
I appreciate that, Masha. It helps me understand what we're talking about. I agree wholeheartedly. Anything that the commission does, obviously, we want to be open and completely transparent in the public. Where I was caught on it still is that I guess it's probably a conversation within the commission, but is the commission going to be taking up complaints and making judgment calls on officers who have cases open? And I say courts, but I'm referring to not just the general court, but civil service and arbitration as well. Because many times we have officers that are found responsible or sustained by the department head that then get appealed through some adjudication process, those three, and the officer is exonerated. The last thing I'm sure the commission wants is to take a vote and possibly influence any type of process of adjudication, because whatever this commission does is immediately printed in the media everywhere. And that's unfair to the law enforcement officer in that case.
But I don't think we have, and I'm sorry to interject again, I don't think that this has just, we're just talking about what the commission's decisions are. I don't think that I think what you're talking about are decisions that we have nothing to do with, whether it's a union issue, whether it's in court, et cetera. This is what we did for whatever reason. We had a hearing, we voted, we came to a conclusion about our decision, and then our decision, the officer has an opportunity to appeal. I think it's important for the and we can talk about this, I guess, or we don't have to make a decision now, but from my perspective, I think it's important that we understand what conclusion means for the commission purposes, but also if we do that and tie it to, we've made a decision, we voted, this is our decision. However, that decision is under appeal. That should also be part of what is transparent to the public. So I think I think the two things that you're talking about, I understand your concerns, but the outside part of it is not us. That's a different issue, whether we decide or not, whether we make a decision while something's pending. This is as far as what goes out to the public.
And I do understand that. I guess my ultimate piece for everybody else who's going to chime in on this discussion is, it seems we need a definition of conclusion, because my next issue is going to be, well, what determines when the commission is going to take something up and vote on it? Are we going to vote on a case that has not been fully adjudicated yet and put something out publicly that the commission has taken a stance for or against a case that ends up blowing up in our face if the officer is found responsible or not? It makes the commission in a precarious position of taking votes on cases that are not fully adjudicated. And that's why I'm stuck on why we would take out the definition of conclusion. At which point in time does the commission decide that we're going to take something up?
And Commissioner Calderon, I think we've had several other commissioners' hands in the air for a while.
Yes, Chair.
Could we hear from them?
Absolutely.
And also, I think our executive director has been trying to say something. So perhaps I could start with Commissioner Bluestone.
Thank you, Chair Hinkle. I would just chime in by trying to cast this discussion in an alternative light, which is really that what we're talking about, at least in my mind, is an issue of reliability and accuracy of the data. And that we're obviously trying to balance preventing data from going into a database that might be false, that might be erroneous, or might have a negative impact on a law enforcement officer, against the risk of not including data that the public is entitled to see and that might be relevant to the issue of the public trust. And so I think really as I think about this discussion, I'm thinking about which is our priority. We are going to potentially open ourselves up to false positives or false negatives in our database. And so I think coming to some conclusion about which way do we want to err might be another way of looking at this.
Thank you. Commissioner West, please.
Thank you, Chair. I think in regard to Commissioner Kazarojan's comment, it seems to me that the decision Post makes is made by a different standard than, for example, the decision that a district court judge would make, or a decision that the internal affairs at a police department would make. We have to remember that we are considering whether a police officer is morally fit to be certified. And that certainly is not the consideration in a district court's determination on a criminal case. So I am of the view that the Post position, the Post determination, stands on its own. And it would be public, and these other investigations or arbitrations are going to have to know that when we make our decision, we're making it on different standards. I think that the compromise that Commissioner Kazarojan offered, which is to make a very clear indication that the case is still under appeal or the case is still ongoing, does give us a bit of a middle road. And further, J2, what we have by a vote of the commissioners, I mean, we can make that vote be by, a quorum of the commissioners. It can be a low vote. It can be not a majority. It could be by less members make a decision that they don't want it public, to further balance and ensure that we're being fair. I think this, when I think about these issues of transparency, I just go back to the reason the statute existed to begin with was because of the lack of transparency. And we have to be very cognizant that what we're doing, people out there want to hear about it, and they don't want to wait until every possible appeal or every possible case that may not even be related or being judged by the same standard is concluded.
Thank you. Commissioner Enrique, have you been, I know your hand was in the air before. I'm sorry, did you, was that, whatever you were going to say, has that now been said by somebody else?
Partially, Madam Chair, if I could just emphasize one point that Commissioner Calderon made at the end of his last remarks. The key question is when the commission takes a particular matter, which is not addressed by these regulations. It's really up to you. That when it comes to disseminating information, as Commissioner Kazarojan is saying, the definition of conclusion is when the commission has made that decision, again, subject to the proviso that was spoken about. But I think there's still a policy question as to, in some of the examples that Commissioner Calderon was imagining, an appeal to civil service, for example, whether the commission will take a particular matter at that time or yield until later, because that's ongoing.
Thank you. Commissioner Calderon.
Thanks, Chair. Thank you, everybody. I appreciate it back and forth. The only thing I have is Commissioner West. I agree with her statements again on transparency and openness. However, I do disagree that although certain members of the general public want information quicker than sometimes is provided, I want to make sure that I'm clear on the stance that it is completely unfair to the officer to have this commission take a vote that will be public that may adversely affect an officer's case. There is absolutely no reason why an officer should be treated any differently or have any less due process rights than any other individual in the Commonwealth. And when this commission makes a decision that could adversely affect the outcome of a case because of a public stance, that is something when it comes to the integrity of this board that I want to make sure that we're all considering. Thank you.
Commissioner Kazarosian.
Thank you. I think we're talking two different things, and Commissioner Calderon, I think with all due respect, I think what you're talking about is whether or not we make decisions before other entities have made one. That's not what we're talking about here. That's a whole different issue. All we're talking about here is when we make a decision, should we make that decision public? Should we disseminate it to the public? That's called transparency in my book. Whether or not we should make the decision has nothing to do with what we're reading here. That's a whole different set of circumstances, other, policies, regulations. This is just dissemination to the public. So what we're trying to do here is, from what I understand, and I could be wrong, is when we make a decision, is it fair to call that a conclusion of the post commission? And decision meaning goes through all the processes within the commission. From my perspective, if we're going to really be consistent about transparency, we should make that public, but we should also make public any information as to the fact that that decision may be on appeal. If we make decisions and come to a conclusion by whatever standards that you may or may not agree with, and I fully understand your position, I do. But if that decision is made by the commission and we don't make it public, that's not transparency. So I think we have to make a decision. That conclusion probably means that all remedies and all issues before the commission have been concluded by a final decision. That goes public. If it's been appealed, that goes public. And I think that's all we're talking about right now, not the process of whether we should wait until like a union issue goes through or public service. So I think that's where I'm having a confusion on this.
And may I suggest at this point that if there are commissioners who have not yet spoken, who would like to address this issue, we hear from them, or if there are other aspects of this that have not yet been stated, that we hear that. Otherwise, I think this has been a useful discussion. I would suggest that we leave it to our general counsel at this point, given the remarks that have been made, to consider those remarks and bring before us at our next meeting language which would attempt to address them. So again, I come back to whether there are any other commissioners who have not said anything, who wish to make a comment at this point, or if there are any other issues that have not been raised by the dialogue that has occurred, that also be addressed at this point. And I don't think I see.
I would just like to make one additional point, if it's all right.
Of course.
I just wanted to respond to Commissioner Kazarosian, and I agree fully with the point that you're making. And the additional question that I would just raise for consideration is that, if we are making decisions and we are making them public, then the reliability of that data hinges on whether our decisions are correct or incorrect. And I think that hinges on the information that we have available to us relative to other procedures through the courts. And so my question would just be, do we have enough information available to us in these cases to consider our decisions reliable?
Thank you. And I think with that, perhaps back to you, General Counsel.
Thank you. Okay, just moving on, this subsection 5 now allows the commission to eventually structure the database so that certain sensitive information is included in the public database, technologically speaking, but it's made unavailable to the general public and available to certain individuals who are legally allowed to receive it. And so that is based on the fact that some of the statutes and regulations cited here that provide for confidentiality allow for certain types of information to be released to certain people, law enforcement, victims, professional groups. And so this section would allow the commission to, at some point when it's technologically feasible, to structure its database so that it gives some people some special additional access if they qualify. This subsection 6 raised issues, that is, comments from people concerning the provision of guidelines, our agency's provision of guidelines regarding its application of the public records law and the length of time until a conclusion is reached, which is what we just discussed. And so it was revised to make even clearer that it is really merely advisory. It's not binding. So now the way that it reads, commission personnel may ordinarily treat the following guidelines as instructive to the extent that they do not conflict with any governing source of law. And to make clearer that it provides guidance regarding one discrete issue, and that is basically when a matter is active, when it's subject to commission oversight, when it's it no longer uses the word ongoing, but it's basically the same concept. And it does not purport to resolve questions about the application of the public records law. In other words, when it comes time to apply the exemptions under the public records law, it will still be necessary to look at the tests that they provide and to apply those. This would really just address one data point that sometimes comes into play in the course of applying those tests. And it now redefines the point when a certification or a disciplinary matter is no longer active. And in this case, it provides for matters to be active until such time as the commission has issued its final decision and the officer has waived or otherwise lacks an entitlement to review of the decision by the commission or any of its personnel or by a court under Chapter 30A. However, because this is merely advisory and because public records determinations will ultimately be based on a case-by-case application of the relevant standards in full, and because the above provision regarding the conclusion of disciplinary matters has been revised, although I realize that remains an open question, this subsection will rarely be applicable now. And yet it's been the subject of comments, and these provisions could not be changed without full promulgation procedures. So perhaps they should be cut from these regulations, leaving the possibility that similar guidelines or principles could be adopted less formally. So I don't know if there are comments on that. I think right now I would put that question out there and suggest that provision that provides guidelines no longer has that much utility, that if it is the source of any concern, that it's necessarily worth including. I see a hand.
Commissioner Kazarosian.
Yes, because it's so, regulations are so difficult and to change if needed, and we evolve quite often and frequently given certain situations. And because most of the things we're talking about here are already covered, I think, by the public records law, it might be a better way to address this by making this policy instead of into a regulation. Policies are more easily adapted as things change and can be changed more quickly as we need them to be changed. Whereas if we put them in as a regulation, it's very rigid. So I would support adopting these as policy rather than including them in regulations here.
Marcia, may I inquire as to the breadth of what you're just talking about when you said them? What were you referring to?
Well, some of the issues, some of the things that talk about when we're going to release information, under what circumstances, what would be considered a public record, how we would address them. I think the ones that, I think that's most of the things that I remember going through, and maybe they've changed. Randy had support, General Counsel had support with backup from the public records law, or so that it was already addressed, so that we may not need to address them here in regulations. We can just adopt them as policy.
In other words, you're talking about a portion of what is in front of us now.
Right.
I see.
Okay. Are there any other comments on that? Okay. So I'll just move on. This subsection 8067, which deals with the inclusion or exclusion from the public database of additional forms of information in accordance with future guidelines, has been clarified, and it adds that any determination about additional inclusions or exclusions of information made by the commissioners should follow an opportunity for public comment. And I just want to be clear, that was something that was suggested by a commenter, but this provision provides for guidelines to be established by the vote of the commissioners, or if no such guidelines are established, to be established by the executive director. And so the part about public input was added to the language about guidelines established by a vote of the commissioners, not guidelines established by the executive director, on the idea that larger policy questions, more significant matters, would be put before the commissioners for a vote, and the guidelines established by the commission's executive director would probably be smaller matters or matters that needed to be decided very quickly. And so the public input language was only added to the part about guidelines established by a vote of the commissioners. Subsections 807, 101 and 2, which concern the design of databases and record keeping systems, were slightly revised to make the language even closer to the precise language used in the public records law. And then there are these two new subsections were just added this week, and they provide for the commission to protect the security and integrity of its databases and prevent misuse. Specifically, they state that the commission shall implement safeguards to ensure the security and integrity of its databases, and to the extent otherwise provided, the confidentiality of such databases. And the commission shall take reasonable steps to prevent misuse of any commission database by any of the commissioners, staff, vendors, contractors, or agents, which steps shall include, but need not be limited to, prohibiting use and access to the database for purposes other than commission-related business, and prohibiting improper disclosure of confidential information. Section 808.10 still aims to protect the ability of individuals to correct apparently inaccurate information in their personnel records, but this provision was clarified and it was expanded to apply to private as well as public employees. Now, these next two sections, 809 and 810, concern the handling of records requests. And you'll see those two are also in blue because those are things that the commission might want to consider cutting, might find them to be unnecessary. But first, I'll just talk about how they've been revised. They've been revised so that now they omit the provisions that allowed for communication between the commission and law enforcement agencies. That is not meant to imply that such communications would be inappropriate or that the intent behind them was anything inappropriate, but they apparently had been misconstrued. And so there did not seem to be any benefit to continuing to include them. These sections have also been revised to make clearer that what I've called before second tier information, so information that's on a list above where it's not necessarily strictly prohibited from disclosure by some statute or regulation, but it involves a level of sensitivity, or perhaps it's not a public record, so the commission has the discretion whether or not to release it, to make clear that that information will be provided in response to a public records request if it's required by the public records law. So that was always the intent, but was made clearer. And other language has been clarified. And within the provision that deals with charging the maximum allowable fees when information that's been requested is available on the public database, it adds that there would be an exception for extraordinary circumstances. And it also provides that the commission may, but is not required to, withhold documents before payment of a fee that has been charged. Previously, the version said commission shall withhold payment in those circumstances. However, as before, because the steps provided for in these subsections can already be taken under existing law, and yet these provisions could not be changed without following full promulgation procedures, perhaps they should be cut from these regulations, leaving the possibility that similar steps could be provided for less formally. That was something that one commenter proposed. Again, I do not believe that there's anything inappropriate about including them in the regulations. And that's based in part on a survey of other regulations and cases dealing with regulations that concern public records matters. But if there's, is there enough benefit to including them that they should be included? I'm sorry, was there?
I think Commissioner Kazarosian has a question.
No, I just wanted to again say that for the same reasons as I raised earlier, and because most everything in here, I believe you backed up, you are addressed in the public records law. I again think it may better be suited for all of us to make this as a policy rather than in a regulation, because it's so difficult to change them. And if we do have to make some changes or tweak them, having them as a regulation makes it very difficult and time consuming, whereas as a policy, we can still implement it, but change it as the needs evolve.
Yes, Commissioner Bluestone, please.
I just want to express my agreement for what Commissioner Kazarosian is saying. I agree with that.
And let me also add my agreement with the last two commentators. It seems to me that there is little to be gained. These are long and complicated as it is. At this point in time, I would go along with what I think is a general recommendation from our general counsel that this particular section be eliminated in the next draft that we see.
Thank you. And then finally, the last two sections, one deals with privileged information, one deals with compulsory legal process. And they were in certain ways clarified or expanded a little bit to cover situations similar to those that had already been addressed. So I can answer any additional questions.
I don't think I see any additional hands in the air. Randy, let me commend to you and the legal staff, your very careful, methodical work in preparing and presenting this to the commissioners. Also, I think I appreciate the comments of my fellow commissioners on this. I think we leave you, our legal staff, with issues to address before our next meeting. I'm sorry, Commissioner Calderon, you do have your hand in the air, and I apologize for not having seen it.
That's okay, Chair. I actually took it down. I appreciate it. I wanted to let you finish. I didn't want to interrupt. Is it possible and let me also say, hey, thank you to the General Counsel. I know that we went back and forth on the issue, and he's doing the best he can, him and the staff. But when they come back, Madam Chair, can we also ask the General Counsel if they can get at least some definitions, I guess, maybe to explain openly what the difference between the policy and regulations would be, because it seems to me that either way the commission would be changing either the policy or the regulation, and regulations, as I read somewhere earlier in there, are just guidelines. So if we could ask him to further define it next time we meet, I think it's helpful to everybody before we take a vote on anything, whether we make it a policy or just keep the regulation, if we can do that.
And I think I've seen Randy's affirmative body language response.
Yes. And let me just say, just to be clear, the part that's merely advisory and it's not binding is the part that's designated as guidelines. And that's consistent with what's in the Secretary of State's publication on regulations. But the rest of it that's not worded that way would have the force of law. So.
Okay, so sorry, if we're tackling it now then, so if it's in a policy, then we can just change it? Is that how I understand it?
If it's in a policy, and let's say it's separate from the regulations, it could be changed more easily. It would not need to go through the full promulgation process with a hearing and comments and so forth. Now, when it comes to the regulations regarding the database as a whole, part of the reason why these are presented in the form of regulations is that the statute, Chapter 6E, specifically states the commission shall promulgate regulations for a database. And then there's, just as a general matter, there's some other principles under 30A about when things need to be in regulations, but and sometimes those come into play, sometimes they don't. But when something is not promulgated formally like this, then it would be more a matter of the commission voting at a meeting, and that would be the end of it.
So in theory, and I might be saying this wrong, but so if I understand it, for the policy, there's very limited public input. It's just something the commission could do.
That's right. There would not necessarily be a public hearing. Not to say that the commission couldn't have one, but there wouldn't necessarily be a public hearing. There wouldn't be a formal comment process required.
Okay, that's how I'm stuck on the lines of transparency. I agree with Masha. I agree with what Masha's saying on the transparency front, which kind of conflicts with the idea of making it a policy. I mean, if we're going to make major changes as to the way that the commission's going to conduct itself or make decisions, I would think we want public input, and maybe we keep it as regulations and not policy. But I guess we could tackle that later. All right, thanks, Randy.
Thank you.
And again, thanks to all the commissioners for your comments and to those who have responded to them. May I, looking at the rest of our agenda, now make the suggestion, in part, Randy, given the extent to which you have matters to address, could we move on at this point to item number 4, go through the rest of the agenda, and then if we still have time, address item 3B, or do you feel that it is imperative that we address 3B today?
It is not imperative that we address that today.
All right, then unless any commissioner objects, May I suggest that we move on at this point to item number 4. We will table 3B until consideration until our next meeting, unless the rest of this agenda moves very swiftly. And then we will be able to proceed with the remainder of the agenda, which includes a number of other matters that I think may take some time and consideration. Again, if Randy is acceptable to that.
Yes, thank you.
So item number 4, the general counsel update, the process for lifting suspensions. Again, to you, please.
Thank you. I will turn the floor over to Deputy General Counsel Lightfoot.
Good morning, commissioners. Good morning, attendees. I'd like to take a minute to discuss with you the delegation of authority to the executive director for administrative suspensions. As has been mentioned today, there were 3 types of suspensions that this commission voted unanimously to delegate to the executive director to impose. One type of suspension addressed felonies where we have a charge, an indictment, or an arrest. There are 2 other types of suspensions that were administrative in nature. One referred to the imposition of a suspension for failure to complete the in-service training. The other type of suspension addressed whether or not information was disclosed to this commission where the officer had a duty to present that information. Let me try to share my screen and share these with you. So, as I was stating, the first type of suspension is not at issue here today for the delegation, and that would be with regard to an arrest or charge or an indictment. And if the commission would permit, we'd like to reserve the opportunity to come back at a later meeting, hopefully the next commission meeting, and address that. But the next 2 types of suspension are what we would like to discuss with you briefly today. There's no governing law in either Chapter 6E or any promulgated regulation that would permit or that outlines a process by which the suspension can be lifted and the certification can be reinstated. Therefore, if the executive director is granted the opportunity to lift those suspensions, then it would facilitate something orderly with regard to the commission, and it would also permit that officer to be reinstated. And with regard to the first issue here of in-service training requirements, the last sentence states the commission shall reinstate the certification of the officer upon completion of the in-service training requirements of the commission. With regard to the failure to report, when there's a duty to report, once again, it states that the commission shall reinstate the certification of the officer upon completion of the reporting. So it is our recommendation, based upon these administrative suspensions being remedial and non-punitive, that at the end of the compliance with these, that the executive director be granted the opportunity to lift that suspension and reinstate the officer. And Madam Chair and General Counsel, it is with that information that we recommend and request that the executive director be delegated that authority by the commission.
Thank you very much, Veronica. May I ask whether there are questions or comments from my fellow commissioners? Yes, Commissioner Calderon, please.
Thank you, Madam Chair. If there's no further need for discussion, I'll make that motion.
Thank you. Again, I don't think I see. Is there a second to the motion?
I'll second it, Madam Chair.
Thank you. Any additional questions or comments? If not, let me call for a vote on Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes.
Commissioner Sherry,
yes,
Commissioner Ellison,
Yes.
Commissioner Casarosian,
Yes.
Commissioner Luma,
yes,
Mr. West,
yes,
Mr. Wynn,
yes,
and I also approve. The motion is unanimously carried. Thank you very much. Veronica, thank you very much for your presentation. And we move on now to item number 5, the finance update, and turn to our Chief Financial Officer, Eric Rebello-Pradas, please.
Thank you, Madam Chair. I'm going to share my screen for the presentation here. There it is. Okay. All right, my apologies. Can everyone see that? Oh, let me put it in, there we go. That's probably better there. Okay, everyone can see that okay?
Yes.
All right, excellent, very good. Okay, so we have some, this is our Q2. We just finished up Q2 in December 31st. So now that we've passed our second quarter, we're already halfway through the fiscal year, FY23. So I just want to give you a quick update on that. And then we're going to get into some updates on Salesforce project, the big Salesforce project, as well as FY24, going into FY24, which will be the new governor, Governor Healy, will be filing her budget on March 1st. So we'll get into that. All right. So right now we are still trending under budget, as with Q1. Payroll is under budget by about 9%. Again, this is really because of fluctuation of hours for non-FTEs or post-retirees, because they are set up hourly. Also, we have the pace of onboarding, which is really attrition. Positions that we have that are open right now, we have 24 positions, or we will have 24 positions filled as of next week. So, we're still down a few because we're looking to get about 31 positions by the end of June. So again, we have that considerable savings that we're getting through not having those positions filled just yet. And of course, we'll get better at that as the years go on. But for now, it does amount to a good amount of money. Now, legal services consulting, as expected, because of the shift with being fully staffed, or almost, I shouldn't say fully staffed to the legal division, but certainly they are a lot more staffed than they were at the very beginning. So we are seeing a shift in cost from our legal services consulting over to the legal division. So we have some savings there. And then, of course, rent. Right now, we know that we probably won't be moving into our new facility down at 84 State Street. We haven't signed a lease or anything yet, but that's still not going to happen until probably July 1st. We thought that we would be in there a little bit sooner. So as a result of that postponed move, we do have some savings outlined there as well. And then finally, information technology. We do have some delayed invoicing. That, of course, doesn't really need to show savings, but it does indicate on the Q2 activity chart that we are behind in terms of billing. We've had a small snafu in terms of invoicing with the vendor, but that has or is being resolved as we speak. And hopefully we should be able to get some money out the door later this month and February. So we'll see some expenditure activity for Q3. Now, the information technology piece, I also wanted to note that one of our major vendors, Last Call Media, will no longer be required as many services as we've been using by the end of this month. So we actually will see some savings there, some significant savings, because we won't need their services for as long as we had initially anticipated. So with this in mind, we're under budget. We have some savings. Let's talk a little bit more about the Salesforce project and IT. So what I wanted to point out here is that you may recall that the BAFO, or best and final offer, that we got from the Slalom and Smartronix vendor was about $2.5 million. But remember, we had to pay for some other things as well, which was, again, Last Call Media, Salesforce licenses, things like that. So we really only had about $1.9 million for direct development costs. Now, after we have incurred, as you can see there, the 2.5 million BAFO, the 1.9 million is made up of the first statement of work, which was really the discovery period for the Salesforce project, $363,000. We've also incurred and just finished task order 1, which was $657,000. So we've incurred about $1 million so far, and we'll certainly get that out the door soon. And that would leave us with about $880,000 for the remainder of the 24 weeks of the fiscal year. Now, the good news is because we have seen significant savings, we are able to actually advance some work that we were keeping for FY24 and move it into FY23. So you can see there, TPC balance needed for FY24, 628,000. Well, we have considerable savings now, so we're able to do that work now before the end of June 30th, as opposed to waiting until FY24 to do the work. So now you can see with the revision, we'll be requiring less money in FY24 for the Salesforce development as opposed to FY23. So actually, we're in a much better position now. So 2 things get achieved: less money needed for FY24, and number 2, we actually get project work completed sooner than we had originally anticipated. And of course, with IT work, this is something that's always to be expected. Moving on to the next slide, this gets us now into FY24. As I said before, Governor Haley will be filing her budget on March 1st. She gets an extra, the incoming governor gets an extra 8 weeks. Now, of course, or I should say 4 weeks, excuse me. So, of course, what we had done is, because A&F puts their budget together so soon, we had to submit some numbers, preliminary numbers, back in November. So we had done that based on maintenance. Now, what is maintenance? Maintenance is really just what is the least amount of money you need to continue doing the goods and services that you did the prior year. That, as you know, doesn't really apply to post because we're building the plane as we're flying it. So we're not in a maintenance mode right now. We can't really do that. But for all intents and purposes, and to satisfy A&F's rules, we said, okay, fine. FY23, our base on the bottom there, $5 million. That's pretty much what we were allocated. It does not include the one-time expenses for Salesforce, which was that $2.5 million that we were talking about just earlier. That's considered one-time expenses, so that wouldn't be part of your maintenance. So they're looking at things like from year to year activity. So for FY24, you see a bottom line total there of $11.1 million. You're probably thinking, oh my God, we're more than doubling our budget. That's not true. We're not more than doubling it because remember, we are not including the one-time expenses in FY23. So actually the better comparison would be 8 million in FY23 to 11.1 million in FY24. And again, these are preliminary numbers. All these numbers that you see here are pretty solid. However, IT is very fluid. Very fluid. So we know that we are going to see some differences there. We do believe that by February commission meeting that we will have a much more refined number, and it'll be closer to what will eventually go into the governor's budget should her office agree. I'm just going to go through a couple of highlights on the FY24 budget. So payroll, this actually would include an additional 10 FTEs. So this would get us to a total of 41 FTEs by the end of FY24. And we'll actually, your packets include the org chart for FY23. So you can see the 31 that we're looking for before the end of this fiscal year. And then by the time we have the presentation for February, you'll have the FY24 org chart as well. Now, of course, the office space lease does include a lot of one-time items like furniture and IT equipment and cameras and things like that. So that number is a little bit high there, but that's only for, one time. But most of that, about $600,000 a year, will be the new lease that will be coming into at 84 State Street. And then information technology, again, this is mostly predominantly Salesforce development, Salesforce maintenance, all those types of things. That $4.1 million that you see there, it's in red. Why? Because again, that number is fluid. It's probably going to go down about $1.5 to $2 million Well, why is it going to go down? Well, again, like I said before, we're able to advance a lot of the work to FY23, so we don't need it in FY24. Number two, the last call media, which they're leaving at the end of this month, we're not going to need them most likely, or not as much, in FY24. Well, we had budgeted $1.1 million for a full year's worth of work. Since we're not going to need them that much, we don't. That's a considerable savings for FY24. So that's something that we can certainly look forward to. Again, we'll have more refined numbers in February when we get close to filing the actual budget. So where does all of this leave us? Well, it basically leaves us with our final budget is probably going to be for FY24 somewhere between 9 million and 11.1 million. My guess is it's going to be closer to the 9, certainly. But again, you never know with IT development and so forth. So what we expect to do is, coming in our February commission meeting, we do expect to have a vote for the commissioners that can take on the FY24 budget, accepting it. And again, the number there should be very, very close to what we expect will be filed in the governor's budget on March 1st. If there are no questions, and I know that was rather quick. Yes, Commissioner Bluestone.
I don't have a question so much as just a comment. I just wanted to say how amazing this is when you think about it. Over the last 2 years, all that this group has accomplished, shifting away from the contracted services to filling positions, the additional workload that people are taking on because it sounds like we're currently understaffed, the move more quickly than expected to complete the project, the Salesforce project. I just wanted to commend you for all of that great work. It's really amazing to see this business grow.
Well, it's a team effort, Commissioner.
Thank you very much, Commissioner Bluestone, for that comment. I know the other commissioners agree with your commendation. And let me also commend our treasurer, Commissioner Ellison, for the collaborative effort that he has made in dealing with Eric and his team on this. And I see he has his hands in the air. So Commissioner Ellison, please.
Yeah, I just thank you, Madam Chair, and Commissioner Bluestone. You're absolutely right. The work that they've been doing, and I've had a front row seat on behalf of the commission. So I truly wanted to just say thank them for the work and including me extensively in these conversations. I just had one question for Eric. The COLA, is that going to be decided for the cost of living adjustment for the staff for the February? For the commission to vote on that?
So that would most likely, well, we did include a certain amount of COLA within the FY24 budget. I think it was, I think we kept it at 6%, but of course that's up to the commission as to whether they want to do 1%, 2%, 3%, 6%, whatever it is. We put in a pocket of money there though. We would most likely not be voting on that. And you would most likely not be voting on that in February. We would probably save that for later in the fiscal year, Commissioner. My recommendation would be probably for some time after the full budget is complete in June, sort of similarly to what we did the prior year.
Thank you.
Of course.
Are there any other questions or comments from the commissioners? And I don't think I see any other hands in the air again. Thank you very much, Eric and your staff. And I think with that, we turn to item number 6 on the agenda, matters not anticipated by the chair at the time of posting. I don't believe that there are any. And so at this point, we would take a vote to move into executive session in accordance with the statutes that provide that the executive session would address the investigation of charges of criminal misconduct, and to the extent they may be applicable, also the initiation of preliminary inquiries and initial staff review related to the same and regarding certain criminal offender record information, and also any matter in anticipation of discussion and approval of the minutes of prior executive session meetings. And at this point, I would ask whether there's a motion to go into executive session.
So move for the reasons stated by the chair.
Is there a second to that motion?
A second.
All right, let me take a vote, please. Commissioner Bluestone,
Yes,
Commissioner Calderon,
Yes.
Commissioner Sherry,
Yes.
Commissioner Ellison,
Yes.
Commissioner Kazarosian,
Yes.
Commissioner Luma,
Yes.
Commissioner West,
Yes.
Commissioner Wynn,
Yes.
and I also approve it. It's unanimously approved. To members of the public who are in attendance, we will not be resuming after the executive session, the public meeting. Thank you very much, members of the public, for attending the meeting thus far. And I think with that, we have concluded this open meeting.